And I welcome you to a session of oral arguments before the 5th District Court of Appeal. I'm Judge Jim Edwards. I'll be presiding. With me are Judge Rand Wallace and Judge John McIver. We will be allotting 20 minutes per side for the appellant. Typically, we reserve 5 minutes for rebuttal. If you want anything other than that, that's fine. Just let us know. In the meantime, if you have a phone or something that might make noise, please turn the sound off. Don't turn it all the way off in case we need to find somebody if they disappear from our screen. So with that, Mr. Duncan, we will proceed.
Good morning. Excuse me. Good morning, and may it please the court. Thank you very much, Your Honors. Michael Duncan on behalf of the appellant, James Philip Kincaid. If I could, Your Honor, I would like to reserve the 5 minutes for rebuttal. Thank you. As the court is, I'm certain, aware from the briefing, this is an appeal of a final judgment of dissolution of marriage from a long-term marriage. The issues that we've presented on the appeal and what I'd like to focus on in my presentation today concern equitable distribution, alimony, and the court's imposition of or the requirement that the now former husband maintain a life insurance policy as security for the alimony award. And if I may, I'd like to begin with the last point, the life insurance issue. We believe we've briefed this thoroughly, but I would like to just review for the court's benefit our points. While the statute does not require a special findings or particularized findings with respect to special circumstances justifying the award of life insurance to secure alimony, this court, the 5th DCA, has repeatedly for many years specifically required that those special circumstances and findings concerning the existence of those special circumstances be made by the trial court in awarding life insurance to secure alimony. Moreover, as the statute requires as well, ability to pay, the availability of the insurance, all of those have to be incorporated within the court's within the court's detailed findings. That was not done here by the trial court. On that point alone, reversal is required. Turning to alimony. The former wife has conceded that reversal is required with respect to alimony. That said, this counsel is well aware that concessions of error are not necessarily binding upon this court. So I would like to review, at least briefly, and address any questions the court has, the errors that we find and have pointed out concerning the trial court's alimony findings. As the record is clear, the original final judgment that the trial court entered here improperly based its alimony determination and calculations on the parties' gross incomes. That is improper under the law. After the motion for rehearing was filed, the trial court noted that and then issued its supplemental findings. The problem—
Didn't those supplemental findings specifically say that the judge used net versus gross?
Absolutely, Your Honor.
Determining alimony?
Absolutely, Your Honor, he did. The problem now is, and the error now is in those computations. First, for lack of a better term, the trial court used ballpark figures in its supplemental findings. As an example, the trial court made a finding that the former wife's actual need computed after reviewing after working from net income actually totaled $4,411.09 per month, but then rounded it down to $4,000. Okay, essentially saying, well, there was a substantial equitable distribution here without any further finding. The trial court then worked through various expenses of the former husband, arrived at an ability to pay that was less than the $1,750 per month alimony award. In fact, it was $1,482.50, but nonetheless made a determination of, well, the husband has the ability to pay the $1,750 because he received a substantial allotment in the equitable distribution. There's a big problem with that, Your Honors. First, and just beginning with the basic determination, if the husband has an ability to pay of only $1,482 per month, it violates this court's whole previous precedent to thus then say, well, he can still afford $1,750 per month without any finding of where that other income comes from. Where does the other more than $250 per month come from the former husband? There's no finding as to, for instance, income that could be immediately derived from the equitable distribution assets or any other source of income. The trial court simply cannot do this. And in fact, there's a very recent ruling from this court, the Horluck case, and it came out after the briefing was completed. It's 365 Southern 3rd 477, in which a very similar set of circumstances arrived where the trial court, without any detailed explanation, ordered the husband to pay support that was in excess of his monthly, the amount monthly that he had after in his net income. So here, the trial court made mathematical errors and computational errors in arriving at what the husband's ability to pay were. And we detail these, Your Honor, in our briefing. For example, if you back out clear expenses that are allowed for the former wife from her financial affidavit, expenses such as for pool maintenance, when there's no testimony that she was going to have a pool because she didn't get the marital residence. That was an expense from the marital residence. Her rent, that from her own testimony, her rent was going to be less than the mortgage and other obligations for the marital home. Expenses such as the difference in her monthly food and living expenses, where although she listed them on her affidavit at one figure, after the trial or from the trial, the testimony bore out that her actual expenses for those items, food and household expenses, were actually $235 or more or less per month. So, Your Honor,
Mr. Duncan?
Yes.
Excuse me. A lot of the errors that you're describing, it sounds to me like there is evidence, it is competent, it is substantial, it's just applied wrong. Do you want to address that? That is our standard, correct? Competent, substantial evidence?
Well, certainly competent substantial evidence is the standard, Your Honor. However, the competent substantial evidence, in order for evidence to be competent, it has to be accurate. So if an individual puts on their financial affidavit prior to trial that my monthly expense, for instance, is $265 for pool, but at trial it's ascertained, well, that was a pool expense for the marital home and there's no testimony that you're going to have a pool in your new residence, well, then that's not competent evidence. So I on the one hand, I agree with Your Honor that in part, this is while there's competent substantial evidence, it's not supportive of the finding that the trial court made. Further, there is evidence, while there may be substantial evidence concerning certain expenses of the former wife, it is nonetheless not competent because it doesn't hold up to her own testimony. So if she presents an affidavit that says one thing, but then at trial says something else, we can't then look back at the affidavit and say that's competent evidence.
Well, we don't look back at all. The trial judge looks at that and makes a finding.
True, but the role of this court is to say, well, is to look and say, well, if that finding is not based on competent substantial evidence, certainly this court needs to look at the evidence to determine, was it competent, was it substantial? If with that being the standard. The point being here is we have clear, number one, mathematical errors. Number two, we have an improper ballparking of what the party's respective need and ability to pay is. And moreover, we have a final judgment now based on the supplemental findings that's clearly in error, because it makes a finding that the former husband only has an ability to pay $1,482 per month, but nonetheless orders him to pay an amount higher than that, an amount of $1,750. And there's no authority from this court or any other that justifies ordering a party to pay in excess of their ability to pay, where there's no detailed finding made as to the existence of any other income that could make up that gap.
So taking your argument that opposing counsel concedes that this may need to be reversed and remanded, but that they claim the error went in your favor rather than in theirs, and that they're actually entitled to, I think it was $4,000 in need as opposed to what the judge found. Do you want to address that? Is there any part of this order you're asking us to affirm?
Well, no, there's no part of the order, Your Honor, that we're asking you to affirm. We believe, and our position is simply this, that where the trial court has mistakenly computed alimony, that if upon remand, it needs to go back and recompute it. And we're not saying just from our side, we're recompute this looking at what is the actual need, because that was part of our argument in our briefing, Your Honor, is that we believe the court improperly assessed her need on the high side, that it should be lower. We understand that they have an argument, they have a counter argument. What we're saying is the trial court on remand needs to readdress alimony from square one, both need and ability to pay.
So going to what I think was your number one argument being reached third, the equitable distribution portion of this. If the need is calculated based upon what's left after the equitable distribution, and we were to find on your first issue that the equitable distribution was wrong, do we even need to reach the other issues?
I believe you do, Your Honor. And I believe you need to reach the other issues, because while typically what we see is if there are some instances where equitable distribution has to be recomputed, and therefore the court doesn't have to address issues such as child support or alimony. In this instance, on equitable distribution, we are not looking at any assets that are found or even argued to be, say, for instance, income generating. And so our argument is that these issues all need to be addressed, that there was error with regard to equitable distribution. It needs to be sent back to the trial court to readdress those errors. Further, the alimony error is separate and apart from the equitable distribution. It also there needs to be remand to the trial court with instruction to readdress all of those errors, and frankly, to start from square one on alimony based on the evidence that was before the trial court at the time of trial. And then thirdly is the issue with respect to life insurance, which I already addressed.
Talk to me briefly, counsel, about the IRAs. It looked to me as though you did put in evidence with regard to the return on the investment, and there was testimony from your client that because of his job, his employment, it would be very difficult for him to manage it. So that's why he had Morgan Stanley or whoever it was do all the investment decisions. Is that right?
That is correct, Your Honor. And in fact, it just another case that just hit from the fourth DCA on this point was the Naranjo case, which is 366 Southern 3rd 11. It just came out in July of this year, which addresses this issue, the issue that we tried to highlight. That first, the fact that the husband was not involved in any of the investing decisions concerning his IRA rollovers. That case supports the argument that this is passive versus active. In other words, passive versus marital efforts. So
beyond counsel, beyond just submitting the Morgan Stanley statements that showed the average return on the investment, did you present evidence of, if you look at the IRA Roth account that was non-marital, here's what the passive income would be, and on the standard IRA, here's what the passive income would be, or did you just present the statements?
It was the statement, well, it was statements, but then it was the statements also showed what the rates of return were for those funds. And because those funds were all invested, there was the Roth and then there was the standard. Each of them was invested, all the funds in those accounts were invested in the same manner based on the husband's testimony. In other words, our argument is those average rates of return applied to those passive.
I guess my question, and I'll try to keep it short so that I don't eat up all your rebuttal time, but on the Roth, say if the rollover Roth had 6% interest, did you guys present to the judge, well, if you look at the non-marital contribution of X dollars times and add in the 6%, here's the number you come up with?
Now that was not presented, Your Honor. What was presented was this is the amount and apply it to the passive.
All right. Do you want to save the rest of your time for rebuttal?
I will, Your Honor. Thank you very much.
Okay. All right, Attorney Byland. You need to unmute yourself. There you go.
Good morning.
Good
May it
morning.
please the court. My name is Corrine Byland and I represent the appellee, the former wife, Deborah Kincaid, in this matter. When I was preparing the answer brief, I saw some 12 issues actually raised in the initial brief, and we conceded on many of those. I'm gonna try to present my part of this case in an order that makes sense. Mr. Duncan started with the life insurance issue. I believe due to the change in the statute that happened on July 1st, if this court is going to remand the alimony issue, which we conceded that the alimony issue did probably need to be remanded, we're back to the trial court. The case is now pending, and the new statute, which does require additional findings to tag a person with a responsibility to secure alimony with life insurance, that would apply. So I think that the life insurance issue kind of goes away because of the fact that the alimony needs to be remanded. And there was a lot of time spent on the alimony issue in opposing counsel's portion of this oral argument. And for my part, I feel that it's fair to say, and it was fair for my client to concede, that there was error when the trial court determined Mr. Kincaid's ability to pay. We feel that his ability to pay was probably greater than the court determined, but the findings that were included in the supplemental findings after rehearing, where the court went back and really tried to drill down on the need and the ability to pay and the net incomes of the parties. When the court said he only has the ability to pay this much, but I'm gonna kick it up to $1,750 because because I think he has it. I think the judge was right. I think he does have it. I think he does have that ability to pay and more, but I concede that that was an error that this court cannot ignore. So the alimony issue, I think, goes back, and with it goes back the life insurance issue as well. So those findings were, I believe, very good. I think that the trial court intended to really drill down on the details and look at the competent substantial evidence that was presented at the trial level. And I think that there was a lot of evidence presented. It's not uncommon for any litigant to admit that maybe some of their expenses were different than what they were presented on their financial affidavit. Clients are very unsure what to put on their financial affidavits because amounts fluctuate, frankly. Power bills aren't the same every month, and these things happen. But
Counsel, let me interrupt you just for a second. The one example your opponent picked out was the pool maintenance expense of whatever it was, $263 a month. Do you agree that that should not have been included as part of your client's expenses?
it's arguable. And the reason why it's arguable, Your Honor, is that the alimony statute requires that the court consider the expenses as established during the marriage. And there was a pool during the marriage. I believe that my client's original financial affidavit was prepared while she was still living in the marital home. And it was fair for her to go ahead and include those expenses that were established during the marriage. So I don't think that that pool expense alone is the reason why this needs to go back on remand. I do find it interesting, the difference between someone's actual expenses versus their standard of living as established during the marriage. So I think that it's fair for a court to conclude that maybe their need as established during the marriage might be higher than their actual need at the time of trial, because people downsize. When you're in litigation, you try to put yourself in a position where you're not incurring debt, where you're not going to be destined for, financial ruin. So you do kind of take a wait and see approach. And Mrs. Kincaid was fine to include that expense on her financial affidavit.
Let me ask you this. It's my understanding that your client basically adopted the household expenses from the former husband's affidavit, correct?
I think that is largely true.
And the trial court discounted or disallowed certain expenses that the former husband had on his affidavit, yet allowed the wife without any hesitation those same expenses. Can you explain that?
I think that the expenses that the trial court took out of Mr. Kincaid's expenses were related more towards the support of the adult child. There was an adult child living with Mr. Kincaid, and he included expenses for that child, significant expenses related to that child's post-high school education and things of that nature. And I think that the court did an admirable job trying to segregate out what were those expenses versus the expenses for the husband and for the minor child. I think that's very difficult.
Do you agree that the $74,000 or $70,000 loan repayment, if that's what it was, to the father from the former wife, that needs to be analyzed by the trial court on remand?
Your Honor, I believe that it's already been analyzed by the trial court.
Where is it? Where is the analysis in the final judgment or the supplemental findings?
There is none. There is no analysis in the final judgment or in the supplemental final judgment regarding the $74,000 loan. And I think that it may have been cleaner if that were included, but I do not believe that 61075 requires a trial court to find there's an asset or a debt where there is none. There is no requirement under 61075, which requires a trial court to address every single allegation made by every single litigant. That would actually be an extreme requirement on a trial court, and especially in family law proceedings. But 61075 did not require the trial court to address the $74,000 because it was not found to be dissipation and it was not found to be attributable to my client. Neither was my client, responsible for the Michelle Gorman note, the $3,000 loan that was made to the son's girlfriend during the marriage. So I see the $74,000 dissipation argument in a very similar vein as the Gorman note, the $3,000 note, because I just don't think that the trial court is required under the statute to find something where there is nothing. And then the trial court heard these arguments twice. The court heard them on both trial and rehearing and did not find them worthy of analysis. It just was not something the court felt was includable in the equitable distribution. So those things were, I think, allegations by the former husband that just were not found to hold water. The passive appreciation in the IRAs is something that I want to talk about because this was a huge issue on rehearing. And I want to point out that this was not a non-marital asset. It was not a non-marital asset. Former husband keeps arguing it's a non-marital asset. It lost its non-marital integrity when he took his premarital funds and put them together with marital funds and then opened the Morgan Stanley IRA accounts.
But you could trace, couldn't you trace, or the trial judge easily trace those funds even though they had been commingled? None had ever been withdrawn from what I understand. Is that correct?
I do not know of any information that any money had been withdrawn. What is problematic, in pursuant to, prior case law, Belmont and Frangel, which we, discussed at rehearing and also cited in our answer brief, when somebody takes non-marital money and they put it in a marital account, it loses its,
the whole concept is individual retirement account. Although it may be using funds earned during the marriage, it's not a joint account. I mean, it may be a marital asset as to anything contributed or earned during the marriage, but it's not like putting money into a joint checking account or bank account. It's an individual retirement account. So the commingling there, to the extent you could follow the money and follow the interest, that's the problem I have in terms of treating it all other than the initial deposit as a marital asset.
And I understand what the court is saying, but 61075, I guess it's 6 subsection E includes all retirement accounts in, marital assets. And Mr. Kincaid had marital IRA accounts that he combined with the premarital accounts. The amounts don't match. And we discussed that a lot at the rehearing is that the amounts on the statements presented don't match the amounts that he claims are non-marital. So he admitted at the rehearing that he combined all of those monies. And I do acknowledge that there was a statement presented. It was presented at both trial and on rehearing that showed a certain rate of return, but that rate of return was on all of the money, not just Mr. Kincaid's portion. And because of the fact that money is fungible and all those dollars went together, this was not the same as if it was a stock that was, that kept its separate integrity. Since all the money flowed together and it was fungible, then it became untraceable. And that is our position on the IRA accounts. Now, I did note Mr. Duncan's argument regarding the tax consequences on the Roth versus the traditional IRA. And I did concede that that is problematic and that probably needs to be looked at when we go back. But there's no passive appreciation that Mr. Kincaid should get by virtue of this litigation because it's not authorized under the law. It was not a marital asset. The fact that there was no prenuptial agreement, there was no stipulation that it would be a non-marital asset means that it was a marital asset. And it was problematic.
Counsel, do you agree if he had not rolled them in, if he had kept those two initial IRAs separate as separate accounts, that those would be non-marital?
I do acknowledge that. I think the law supports that. The statute and the case law all support that.
Ms. Byland, just so that I understand, I think what I hear you telling or answering in response to Chief Judge Edwards' questions was, even though when you roll the money into the IRAs and the investment company or the broker can track what's the cost basis, what's the appreciation, you're saying that doesn't matter. And it's all one and the same. It's all a marital asset once that money comes into the account.
It's yes, Your Honor, because it's commingled.
You're
if
saying
it was
that
a house,
as far as the interpretation of the family law statutes, but the reality of it is obviously those companies, that's why your investment advisor gets paid what they get paid so that they can track what is the cost basis, what is the appreciation, what is the interest and dividends, all of that. You're saying that's irrelevant.
yes, Your Honor, because of the statute. If this was a house, if it was real estate, we would say that it was gifted. And it's not a home, so we're not trying to make the argument that it's gifted. We're making the argument that under the law, it was commingled and it was made into a marital asset. And so
even though the asset with technology right now, the asset can be valued real time by the second, based upon the technology that we have, you said that's still irrelevant.
It would be up to the legislature to then work that into 61075, and the legislature can certainly do that. But the statute as it is written right now required the trial court to find all assets acquired during the marriage to be marital assets. It was unfortunate, and we talked about it a little bit at the rehearing, that, my client, and she may have had a good reason for this, but there was no objection to the fact that Mr. Kincaid claimed the non-marital interest. He didn't plead for it. There was not a prenuptial agreement. There wasn't a stipulation that it was going to be tried by consent, but the fact that my client did not object waived that objection. So when the court segregated out those premarital contributions, Mr. Kincaid saw the benefit of that. but now asking for the passive appreciation on those funds as well, I feel is overreaching. Because the statute clearly states that these accounts were marital assets because of the fact that he combined the funds into both of them.
Okay, counsel, do you have anything else or?
I don't. I was just double checking my list and I have nothing further.
Okay, if my colleagues have nothing further, we're back to you, Mr. Duncan.
Thank you very much, Your Honor. Would like to address a couple of points that were made by opposing counsel. First, the Gorman note was brought up. The Gorman note is along with some, there were some bank accounts that we pointed out in our briefing of that were held in only the former wife's name that were not addressed at all by the trial court. 61.075 at the very beginning of the equitable distribution process, 61.075 requires the trial court to discern between marital and non-marital assets. There was plenty of testimony and evidence presented concerning the Gorman note that it came into fruition, or it came about during the marriage, that it existed at the time of the trial. Under 61.075, that makes it a marital asset, and yet the trial court did not address it at all. That's error. Same analysis goes to the several bank accounts held in the wife's name only, but yet it came about during the marriage. The testimony was unambiguous by the wife that she deposited monies of hers into those accounts during the marriage. They had balances according to the financial affidavits. They had balances, and according to the statements that were presented in evidence. Again, trial court did not make any finding concerning them at all. That is error under 61.075. The $74,000, the wife says it was a loan repayment, yet her testimony was all over the place. She couldn't identify what the terms of the loan were. While, and I disagree with my opponent's contention that the trial court's not required to address this. There was plenty of testimony by both sides about this issue, this money. Was it a loan? Was it not a loan? Did the husband even know about it? What were the terms? And yet this money is very clear. It disappears from the wife's bank account right before the dissolution is filed. I think within a month or a few weeks. It was incumbent upon the trial court to at least address this. We have no idea what the trial court's resolution was with respect to it. We believe it was improper dissipation, but at the very least, it needed to be addressed, and it was not. On these issues alone, remand is required. As pointed out, when the trial court is required to make a finding about marital versus non-marital assets and then value the marital assets. And that didn't happen here with respect to these various items.
All right. Thank you, counsel. And with that, we will be in recess.
Thank you very much, Your Honor.